Mr. Westfall, as Douglas is going to come up and introduce our special speaker for tonight. Our speaker is a good friend of our elder, Mel Jackson. In fact, they ride, I believe, Harleys together. And so he has written an incredible book, and his publicist, actually, Mr. Westfall, is going to come up and introduce him and explain his connection with them. So, Douglas, why don't you come up at this time? He was here for a half hour. Maybe a selective rapture occurred. If he doesn't come in a moment, we'll have Mel introduce you. I think I heard his voice. Come on up.
Oh, that might. Well, okay. I discovered something through 30 years ago. A Korean Christian by the name of Gwang Hook Ri left North Korea during the war, never saw his family again. They were killed. For 2 years, during 1950 and 51, he was a monk. He became a monk because he'd lost his family, and he labored with his work at a monastery. It was hidden for almost 50 years, and this magnificent artwork became available, and I, before I gave it back, got permission, and I replicated it. And I have to get the tape off or it won't work. And this is for you. There we go. This is a picture of our Lord Jesus. Okay? And Gwang Hook Ri drew that. Wow. It's the entire Gospel of St. John. Wow. As letters.
Amazing.
Now, if you go online and type in his name, and what I just read to you is down here, you will look at him. He has done maybe 25 smaller ones. He's done 2 large ones that are like 5 feet high. I mean, it's just unbelievable, this man worked. He ended up coming here. I met a Korean minister who said, I know him. And he took me out to Long Beach, and I got to meet the guy before he passed away. And he was just so excited because this was his first work. It is the entire Gospel of John from right here. And I don't know, my eyes are good enough. In the beginning was the Word. Okay? Now, he prayed before he did each line. Wow. He drew the picture in pencil. Can you see that? I'm sorry. He drew the picture in pencil. All right? And then he took 2 Bibles and cut the lines apart, all King James, because he couldn't read English. But he knew the English version would be the most read in the world. And he copied the letters over the picture he had drawn, darkening them when he needed to for the image of Jesus. Wow. I mean, so I replicated it, and this is for you. It's a gift. You got to have this. And
Thank you.
every time I look at it, I want to cry. I can't believe how this happened. And that's what this guy did with the rest of his life, was make these things.
That's outstanding.
And as far as I know, this is the only original one that made it to the United States. And I anyway, when you get a chance, please come up and take a look at this, because you can read it. Okay? It's that unbelievable. And why are you having me do this first? You're more important than I am. Yeah, I don't know. He wants to get rid of me. Anyway, that's a gift for meeting you guys, for having us here tonight, and I appreciate it.
Thank you, Doug.
And it is the most remarkable thing. And read the Gospel of St. John at the same time.
Same time.
Like you said, what we talked about earlier. How does this happen?
Yeah.
That's how it happens.
God designs it.
Yep. Yeah. All right, thank you. That was all I've got. I'm going away. Thanks, Doug. Thank you.
Like Doug said, we've known each other about 30 years or something, and when I wrote this book, I'd probably known him about 24 or 5 or 6 years, something like that. And I called him up and I says, I've got a book. And he says, oh, okay. What's it about? I says, it's about abortion, And he says, which side of the argument you on? Yeah. And I says, I'm on the right side of the argument. He says, okay, I'm in. And he didn't even read it. And he stepped up and said he would publish it. And so I gave him a copy of it, the draft. And he went through it. And then he calls me back and he says, do you know what you got here? This is amazing, He says, what are you going to do if somebody wants to buy this and not let the public see it? And I said, I'll sell it to them one at a time. So they can just have it one piece at a time. Anyway, Doug and his wife, Jackie, are marvelous people, and they were, great to work with on the book. And they helped me do all the editing, and Doug did all the artwork, and all that stuff. He's amazing with it, and I do appreciate everything he's done for us. Thank you very much. Okay, so. Yes. Yeah, he's an author himself, historian, publisher.
What is your full name?
Pardon me?
What is your full name?
My full name, Clyde.
Nobody ever said.
Clyde Granger. Okay.
It's up on the picture.
Yeah. So before I begin, let me again thank the Orange County Community Church, its pastors and elders, for being so brave, considering the political climate that we're in, to allow me this time to share with you on this topic of abortion. It's a tough subject, and with all the things that are going on, it could be, we always think about that, and we should be thinking about repercussions or whatever may happen. But I appreciate their bravery, and they're also being very brave, because there's no telling what the hell I'm going to say, and anything could come out, So, second thing is I'm just an author. I'm not a lawyer. Don't take anything I say as legal advice. Everything I am presenting is my own opinion as an interested citizen. I think that we all should spend time researching the issue that challenges our national conscience, and not trust the media or any political organization, but only the facts that we can prove. For it seems that they are less than honest with the cover-ups, the deceitful presentations, the dismissing or eliminating important facts. I want to invite you to do your own research, make your own decision on anything that is important to yourself and our country. I think that we should do that, and that's pretty much how I got here, as I did my own research. So let me ask a couple of quick questions. Anybody know why this country is so great? Got any idea? You think it's maybe the dirt? We got better dirt than they have in South America. The air might be better, the weather is better, more materials, more raw products. What makes this country so great? Huh? Freedom, right. Where does that come from? Right here. This is the thing that makes us so great. This little thing can fit in my shirt pocket like this. You know, if I had a shirt pocket, they don't give you shirt pockets anymore, but if I had a shirt pocket, it'd fit in here. About the size of a check. You know, if I were paying my bills, I'd pay but our Congress, when they pay the bills, they need 28,000 pages of stuff, but yet our whole government runs on this. Everything is responsible back to this little booklet here. And we should be paying very close attention to this. And so I would recommend that, we've got copies of them here. If you haven't picked one up, grab one and spend a little time in it and learn the rights. They're not just your rights, they're the rights of everybody. And, we'll get to some of this stuff. But let me open with a quick prayer. So, Father, we come before you first to give you all praise, honor, and glory because you alone are worthy. We ask that you send your Holy Spirit so that the knowledge that we gain will become wisdom and that will confound the understanding of those who are wise in their own eyes. Allow us to use this wisdom to be bold and speak out against the dreadful abuse of your creation. We pray that this understanding will bring a healing to our nation. But Father, even if you grant this prayer, we want you to know that we here tonight are so grateful for our salvation that comes from you by the sacrifice your Son, Jesus Christ, has made for us. And Father, that you would forgive those who genuflect at hypocrisy, kiss the ring of deceit, and worship at the altars of false pride, the love of money, and ignorance. We ask you bring them to the same salvation that you have granted us. I pray this in your Son's holy name, Jesus Christ. Amen.
Amen. Right. Could you kick the volume up just a little bit?
I'll have to ask them.
Volume up, please.
Thanks, sorry.
Say something, Mike.
Okay. Is that better? Yeah. Yes. Okay. I'm a little soft-spoken. I don't know when that happened, but
I can't hear.
yeah. Yeah, we're both losing our hearing, aren't we, Jim? So the subject I'm here to talk about is abortion being used as birth control. It would seem like so many politicians have sold their souls for their 15 minutes of fame over this issue. When you hear a politician quote Romans 13, and they insist that we follow man-made laws as Christians, we need to question if their laws conflict with God's laws. The sixth commandment, of course, is thou shalt not murder. Romans 13 tells us that their authority is given to them by God. But if they abuse that authority, they went right past Acts and they missed 5:29. That tells us that we ought to follow God's laws rather than man's laws. That's first. What is interesting is that there is no contradiction between Romans 13 and Acts 5:29. It fits in perfectly. But as you will see, there's a large number of contradictions and deceptions surrounding Roe v. Wade all the way through Dobbs. There was 48 cases involving contraception and abortion. And they're all based on one fatal flaw. The pro-choice movement will use such phrases as true holdings of Roe, the principles of Roe, the values of Roe, and so on. They never really tell us what that means. They never really tell us what that's about. All these phrases fit nicely into a news brief, but also conceal and even deceive us from the truth. They never explain what the meaning of those phrases are. Because if we were to understand what they are saying, most Americans would not tolerate the abuse of our liberties. So before we dig into the cases that abortion is used as birth control, let us establish at the very earliest stages of development, a zygote is a human being. My wife and I have talked about this, and so we are offering a $10,000 reward to the first person who can prove to me that that statement is wrong. It's out there for you. If you can prove it, I'll accept it. Here's the evidence that must be overcome to prove this statement incorrect. First, the science of DNA has pinpointed an exact moment when genetic evidence reveals that a human life begins. That when the 23 chromosomes from each donor combined, I'm talking about the moment of fertilization, they form a separate set of 23 chromosomes. That resulting fertilized ovum, or zygote, is genetically separate human life. If you are not able to accept DNA evidence, then you must free all those who were ever convicted by DNA evidence. Just open the gates, let them out. There's lots of evidence on this. Go on the internet. I first read about it in a National Geographic magazine. I don't know when, but that's where I saw it. The zygote meets the definition of life, which according to the science of medicine is the property or quality that distinguishes living organisms from dead organisms or inanimate matter, manifested in such as metabolism, growth, reproduction, and response to stimuli or adaptation to the environment originating from within the organism and exchanging gases with its environment. To the science of DNA, medicine, we can prove life, human life, or if you will, human being. No doubt about it. The American College of Pediatrics, in a March 2017 article, enlightened us with, this is a quote, "The predominance of human biological research confirms that human life begins at conception - fertilization. At fertilization, the human being engages as a whole, genetically distinct, individuated zygote living human organism, a member of the species Homo sapien, needing only the proper environment in order to grow and develop. The difference between an individual in its adult stage and its zygotic stage is one of form, not nature. This statement focuses on the scientific evidence of when an individual human life begins, but does not answer the question of personhood." So, if you're planning to respond, please don't respond with "it's not alive until it can't breathe." It clearly exchanges gases within its environment. Please don't tell me that it's just so much surgical waste or tissue. In a case called Box versus Planned Parenthood of Indiana and Kentucky, the Supreme Court ruled that two separate laws passed by the Indiana state legislature, first related to the deposition of fetal remains by abortion providers. The law changes the definition of infectious and pathological waste, thereby preventing abortion providers from incinerating fetal remains with surgical byproducts. The law also authorized simultaneous cremation of fetal remains, which Indiana law does not allow for human remains. In a per curiam, or unsigned opinion, issued without argument, the court upheld that Indiana law relating to the deposition of fetal remains as rationally related to the legislature's state interest. Obviously, the court is recognizing fetal remains are not just so much surgical waste. No doubt about it. Therefore, first, if it is not a human life, then you're stuck proving what you claim it is. Second, if it is not alive, then how does it grow? And third, if it's not alive, why do they have to kill it? Prove me wrong, and I will gladly give you the $10,000. It would relieve my conscience greatly to not have that on me. because I love and participate in the country. Until that day, I remain unchanged and must continue to speak out about this human-made travesty. Okay? With that understanding, we can just accept that this is a human life. Let's begin to unravel the circle logic of this topic. I don't think it is wise to spend time on the circumstances surrounding the cases involved, but rather focus on the rulings of the Supreme Court. I believe that this conversation will bring us to the same conclusion that I have. Abortion used for birth control is simply unconstitutional. That's it. Okay, so in your little folders there, did I just click it?
Switch on the left. Push the center button to see if it lights up your hand.
Something's blinking.
Oh, there you go.
Okay, you got a deal.
Way back.
Okay, so this is our picture of the Supreme Court, and it's kind of a cool thing that Doug put together for me. If we can go to the next one, and here we have our Native Americans, okay? So what I wanted you to do is, if you refer to the notes that we gave you, you'll notice that the first page has a bunch of Latin on it. Caviarentor, I can't even pronounce the second one, but it means a writ of cert. The third one, expressionis unus est exclusionis alterius. The expression of one thing is the exclusion of another. And this is interesting. This is a very tough thing for us to understand when we just say that, the expression of one thing is the exclusion of another. So it would be the example that I was given would be like a men's locker room. So obviously the men's locker room excludes women. Women's locker room excludes men. But today I think we have to say biological men's locker room, biological women's locker room, and so that we can make sure that we're talking about the same thing. And so you'll see that they use this game. It's not always about what they say, it's also about what they don't say. You have to pay attention, because they'll exclude something by just not including it. See? It's interesting. The next one is, and you may have heard this in the news a little bit, it's called stare decisis. Stare decisis. And this is a doctrine that the courts will adhere to precedent in making their decisions. Stare decisis means to stand by things decided. This principle is to maintain stability in the community in law, with the understanding it becomes obvious why case law is so important to the courts. Because if you have a decision that's similar to what that you're presenting, and you can present case law that supports your side, that's why they do this so much, because stare decisis requires it. And to break stare decisis is a huge thing, because when they do that, it puts the court's legitimacy, in jeopardy. People don't quite know what to do with that, and so, they want to do things like pack the court, like what we're hearing from the various people in the Congress, and they want to make their rulings, and they're going to do this, and they're going to do that, so. Anyway, those are the two biggies that I have on here. I don't want to spend a lot of time going through all of them, but I think that you guys should check them out and look at that. Okay, so Griswold versus Connecticut. So I have a little story. I'm sorry, Don. Faster. We talked about this for a moment, right? And so imagine that you got a bunch of guys in a beach community, and they're standing down at the beach, and they say, we ought to have a law. We ought to have a law about girls wearing small bikinis. You know, that'll help out businesses, you know, bring more guys in. If you have a bicycle shop, girls riding on your bikes with the small bikinis, you'll get lots of guys wanting to rent bikes. You know, if you have girls coming to your hamburger stand, there's going to be lots of guys that want to go to the hamburger stand. So these guys that are hanging out down there form a committee, and they set up a standard. You know, she's got to be between 5'2" and 5'8". We'd make an exception for a 6-foot girl, and she's got to weigh this much in each one of these ranges, and you know, weight to. And so they decide to call their group FAT, Fine Athletic Tushes. That's what they're looking for. So I know, I'm sorry. So they form their committee. They go to the different businesses. They tell them about their idea. The businesses say, yeah, that'll work, you know, and then they go to the city board, and they all get together. They have a meeting. Yes, we got to vote, and that's how it's going to go. And then, so everybody's happy. The businesses are starting to grow. The girls get the attention. The guys get to follow them around. And then there's this old couple that decide that they don't think that should happen, and they don't know how to stop it. So they think, well, if we can't beat them, join them. So we'll call ourselves Flabby Arthritic Tushes. And so they get a group of senior citizens, and they all get on their little suits, men and women, and they start marching around, and they lay on the beach, and they line up, and they look like a bicycle rack out there, and nobody wants to go to rent a bicycle. They don't want to go get hamburgers. Nobody wants to sit in the bar, and they're like, what's going on with this? So the store owners call the police. The police got to take care. It ends up in the appellate court. Same decision. You guys broke the law. You shouldn't do this. They go to the Supreme Court. Now they're standing in front of the Supreme Court. And the justices, you know, they do the same routine. You broke the law. You know, we have our standard, community standard. We've got to do this. We've got to do that. And the old guy takes out his little pocket thing. And you can look this up with me. Go to the 14th Amendment. And this was written July 9th, 1868. So where this is over 100 years old. And where I want you to go to is the second page. We're still in the first section. We're going to end at the due process of law. And it says, nor deny any person within the jurisdiction the equal protection of the law. You follow this? Nor deny to any person within the jurisdiction the equal protection of the law. So if these guys can wear the bikinis, so can these guys. See? And just because they're old, you've got a demographic of old, you've got a demographic of young, they have to comply, they have to work together. See? So this little law, this little phrase, written no more than 100 years ago, like coming up on about 150 years now, has probably done more to unite the country than to separate us. When you think about it, there's so much things. Yes. There's so many things here that's happened here. So the other thing that I want you to think about is, like, say you have a neighbor who likes to play his music loud, really loud, right? And they'll rattle the pictures in your house. And so you go over to him and say, hey, come on, you got to give me a break here. I got my rights, and he cranks it up, right? He's got his rights to enjoy his property. His rights stop at the property line. He's got to keep his music inside his property line. I got my rights inside my property line. So his rights end at the beginning of others. Very important concept here. Very, very important concept. Just like on my little thing there about the businesses, it's also the rights of the elderly being pitted against the rights of the young. They have their rights, the elderly's got their rights. So my little example here is kind of a understanding of the first cases that we're going to be looking at, and that's Griswold versus Connecticut. Okay. And Griswold versus Connecticut, the case about contraception for married couples. This decision is based on privacy found in the first 10 amendments, otherwise known as the Bill of Rights. And the majority opinion stated this: though the Constitution does not explicitly protect the right of privacy, the various guarantees within the Bill of Rights created conundrums or zones that establish a right to privacy. The Connecticut statute conflicts with the exercise of this right and therefore is null and void. This decision was given married couples the right to obtain birth control and medical advice for the use of the best method of birth control. Right? Seems reasonable. When we look in our book, we know where the first 10 amendments are. We can turn to the Fourth Amendment. And I'll go really quickly here. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause, and no warrant shall be issued but upon a probable cause supported by oath or affirmation, and particularly describing a place to be searched and the persons or things to be seized. Sounds like privacy to me. I should be private in my own house. Don't want the state just marching in and doing whatever. And this kind of exists because that's what the English would do to the founding fathers and so on. They would just march in, go through their papers, find out that they were involved with the revolution, and take them to court or take them to trial or take them outside and hang them, And so that's part of why Madison put that in there, But I agree that there's privacy in there. We got to have that, that should be there. Okay. The next case that we have is Byrd. Okay. And this was a 6-1 decision. And you say, well, wait a minute, what happened to the other two guys? That's only 7. There's supposed to be 9 on the court. At this time, in 1972, 2 of the justices were falling ill, retired, and hadn't been replaced yet by Nixon. Okay, so the court had to keep going on, so they continued on with 7 instead of 9, and it was a 6-1 decision. The court struck down the Massachusetts law, but not on privacy grounds. The court held that the law's distinction between singles and married individuals failed to satisfy the regional basis test of the 14th Amendment's Equal Protection Clause. Remember that? Married couples were entitled to contraception under the court's Griswold decision. Without that, withholding that right to single persons without a rational basis provided a fatal flaw. Thus, the court did not have to rely on Griswold to invalidate the Massachusetts statute. If the right to privacy means anything, wrote Justice William J. Bannon, Jr. for the majority, it's the right of an individual, married or single, to be free of unwanted government intrusion into matters so fundamental affecting a person as to the decision whether to bear or begot a child. I think I agree with that, I think I agree with that, because if I don't, then I would be saying, well, I'm a white, Christian, Republican male, and then, we'd have other demographics that would be different than me, And would their rights be more than mine? Just because they're single doesn't mean that they... So I agree with that. You know, I don't know how you guys feel about it, but I agree with that. So both of these decisions so far seem real, you know. So the next question is, let's talk about privacy. Okay? So what happens when the police pull you over? What do they want to do? They pull you over, they take you out of the car, handcuffs, before the handcuffs melt. Before the handcuffs. Yeah, we go right to handcuffs, okay. They usually want to search you, okay? And there's several Supreme Court cases that support their right to be able to do that, okay? In Pennsylvania versus Mims, in Mims, the court held that the search did not violate Mims' right under the 14th Amendment, under the 4th Amendment, and in other words, the state's right to search Mr. Mims was more compelling than his 4th Amendment rights. See? In Maryland versus Wilson, in Wilson, the court believed that the overriding government's interest in the officer's safety is to be protected. In other words, the officer's right to safety is more compelling than Mr. Wilson's right to privacy. You follow this? You know, they pull you over, they want to check you out. This is for my safety, I need to check you. You ever heard that? At New York versus Quarles, this is 1974, the court held admissible the defendant's statement obtained without Miranda warnings as to where he had held his gun or hid his gun in a supermarket. Because of public safety, the state needed to secure the weapon immediately. In other words, the state's interest in public safety is more compelling than Mr. Quarles' Miranda rights or his Fifth Amendment rights. Interesting, huh? So Justice Oliver Wendell Holmes, Jr. in Shockley versus the United States in 1919, you've probably heard this, legendarily said, falsely shouting fire in a theater and causing a panic is not free speech. In other words, there's limits to everything. You know, generally speaking, those limits are the safety of the others around me and their rights. So is privacy absolute? What do you think? I don't think so. I think that there's cases where privacy is not absolute. I think that we're proving that. There's other things, like if you go on the internet or you put your name on the internet or you apply for a job, they want to know what your health is. We're not supposed to have to do that, but if you want the job, you're going to have to tell them, you know. If you want to visit an inmate, you have to tell them if you've had shots or not. You have to, you know, et cetera, et cetera. So we can prove that there's limitations to these health, or to these rights, and that we agree with the rights so far. Okay, so now we're coming up on the biggie, Roe v. Wade, and this is the hard one. This is the one that everybody doesn't really get, okay? It's the first case about abortion, and this is where we come to what are the principal values, holdings, beliefs, ideals, tenets, interest of Roe, okay? It is based on the privacy founded in Griswold and the statement made in Byrd. Remember, Byrd was saying about how we have a right to decide if we're going to have kids or not, okay? The due process of the 14th Amendment protects against state action, the right to privacy. The woman's right to choose to have an abortion falls within the right to privacy. The state law that broadly prohibits abortion without respect to the stage of pregnancy or the interests or other interest violates that right. Although the state has limited interest in protecting the health of the pregnant woman and the potentiality of human life. They don't say it's life, they say potentiality of life. The relevant weight of each of these interests varies over the course of the pregnancy. and the law must account for this variability. Okay, sounds reasonable, you know? So Justice Blackmun set up this idea of a trimester system. This is very important. This is one of the founding pillars of Roe, based on a trimester system. In the first trimester of pregnancy, the state may not regulate the abortion decision. Only the pregnant woman and her attending physician can make that decision. In the second trimester, the state may impose regulations on abortions that are reasonably related to the mental health. And the third trimester, once the fetus reaches the point of viability, this is 28 weeks, the state may regulate abortions or prohibit them entirely so long as the law contains exceptions for cases when abortion is necessary to save the life or health of the mother. This is a big deal. So what happens in this case, and it took me a while to find this, Justice Blackmun wrote one of the two opinions, and Blackmun is like the lead on this. This case is an unusual case because it was heard twice by the Supreme Court. They ran out of justices, like I said before. I think it was Oliver Wendell Holmes. Maybe I got that wrong. No, I'm sorry. But anyway, the Chief Justice at the time decided that they needed a full complement, so they reheard the trial. In his first opinion, it was only 17 pages. In his second opinion, it was 50. So he's given some thought to this. He went to the Mayo Clinic where he worked as an attorney, did a bunch of research on his own, and he came back with his decision, I think, made up before he had heard this. So these are quotes from his opinion, and these are very, very important because we've always known that there's something hidden in there, something that we don't understand, that we need to know, and why it's wrong. We know that it's wrong, but we just can't quite put our finger on it. And here it is. The appellee and certain acame argue that the fetus is a person within the language and meaning of the 14th Amendment. In support of this, they outline at length and in detail the well-known facts of fetal development. If this suggestion of personhood is established, the appellate's case, of course, collapses, for the fetus' right to life would be guaranteed specifically by the amendment. The appellate conceded as much on re-argument. On the other hand, the appellee conceded on re-argument that no case could be cited that holds that the fetus is a person within the meaning of the 14th Amendment. You follow this? See this thinking? It's not based on whether it's alive or not. It's based on whether or not it's a person under the law. That's strange. Okay? This is another quote from the same. Texas urges that apart from the 14th Amendment, life begins at conception and it is present throughout the pregnancy. I agree. And that therefore the state has a compelling interest in protecting that life from and after conception. We need not resolve, this is it, this is where it happens, we need not resolve the difficult question of when life begins. They're throwing it out. When those trained in respective disciplines of medicine, philosophy, and theology, okay? So medicine, philosophy, and theology are unable to arrive at a consensus, the judiciary, at this point in development of man's knowledge, is not in a position to speculate as to that answer. So they're throwing out science, they're throwing out religion, and they're throwing out philosophy and rule in favor of their own rules. Drop science, we don't need that. We're moving on. We're going to go with man's rules. Okay? So here it comes. This is the last killer. In areas other than criminal abortion, The law has been reluctant to endorse any theory that life, as we recognize it, begins before live birth. So they don't even recognize life before, when it's in the womb. It has to be escape the womb. This is what they're saying. Or to accord legal rights to an unborn except in narrowly defined situations and except when the rights are contingent upon live birth. For example, the traditional rule of tort law denied recovery for prenatal injuries even though the child was born alive. That rule has been changed in almost every jurisdiction. In most states, recovery is said to be permitted only if the fetus is viable, or at least quick, when the injuries were sustained, though few courts have squarely held so. In recent development, generally opposed by the commentators, or states permitted, some states permitted the parents of stillborn children to maintain an action of wrongful death because of prenatal injuries. Such an action, however, would appear to be one to vindicate the parent's interest in and is thus consistent with the view that the fetus at most represents only potential life. Saying they're just eliminating the idea that this thing's alive or not, doesn't matter. Similarly, unborn children have been recognized to acquire rights or interests by way of inheritance or devolution of property and have been represented by guardians. Perfection of these interests involved, again, has generally been contingent upon live birth. In short, the unborn have never been recognized in law as persons in the whole sense. Okay, you follow this? They're not giving personhood to this human being. Okay, so here's the question. If you've read the book, you've kind of got my take on this. Who else in American history has not been a whole person under the law? Any clues? Go ahead. Slaves. Who else? Women's suffrage. Native American Indians. All three of these are named in the Constitution. And we have a fourth category of immigrants from anywhere. There's plenty of lawsuits and cases that involved immigrants getting rights from the country, and they were not considered whole persons. Okay? So how did they change that? Well, they changed it with slavery got changed with the 13th, 14th, and 15th Amendments. Women's suffrage was the 19th Amendment. And Indians not taxed, as they say in the Constitution, they got a congressional act. An act of Congress is what changed that for them. Unbelievable. So if the abortion issue is not about life, then why is life so important? Why we all know that this is life. Why is that so important if it's not about the child being alive? Nobody? Okay, so in the 5th and 14th Amendments, it says life, liberty, and property cannot be denied without the due process of law. The important word here is life. And if you have life, they can't take it from you without a trial. That's what it says. And they're skipping right over that. Doesn't say, you have to be a whole person. It says person, doesn't say whole person, doesn't say partial person. And you can look it up right now if you want to look for me. And you'll see that I'm telling the truth. That's why this is so important. This is the case that everything hinges on. And this point is what everything hinges on, is that the child is not a person under the law. So when you're talking to somebody, you would ask them, well, what do you believe about Roe? Well, it's my right. Okay, well, explain your right to me. Well, I got the right to privacy. how does that privacy work if a policeman pulls you over? Okay? And so you guys can engage them and ask them the right questions and come to a conclusion that they're the bigots. They're the ones choosing the same argument used for slavery, for women's suffrage, for the Indian Removal Act, for all the things that were done to immigrants from anywhere, et cetera, et cetera. Unbelievable. So let's go to our next case. I want to kind of keep moving here so I don't lose track of where we are. I don't want to go too long. Okay? And this is Doe v. Bolton, and this is another killer. And this one was decided on the same day. It was released on the same day as Roe. And it is just as important as Roe. Okay? Released on the same day as Roe and intended to supplement Roe. The court stated, Roe v. Wade, supra, means as stated above, sets forth our conclusion that a pregnant woman does not have an absolute constitutional right to an abortion on her demand. The court said that. What is said here is applicable here and need not be repeated. Okay? That's right out of the opinion for Doe v. Bolton. Appellates argue that the statutes do not adequately protect a woman's right. This is so because it would be physically and emotionally damaging to Doe to bring a child into her poor, fatherless family, and because advances in medicine and medical techniques have made it safer for a woman to have a medically induced abortion than for her to bear a child. Okay? So they're just saying, well, it's gotten safer, so there's no reason not to do it. A statute that requires a woman to carry an unwanted pregnancy to term infringes not only on her fundamental right to privacy, but her right to life. Crazy. And then it says, we disagree with the district court, we agree with the district court that the medical judgment may be exercised in the light of other factors. This is important. Physical, emotional, psychological, family, the woman's age relevant to the well-being of a patient. All these factors may relate to health. This also, this allows the attending physician the room he needs to make his best medical judgment, and it is room that operates to the benefit, not the disadvantage of the pregnant woman. Okay? So here's what they're saying. Physical, I agree. Emotional. I just can't handle this. I got too many kids. I got to go to school. I can't. It's gone, right? Psychological. I'm breaking down. I just can't keep up with this. I got too many kids. It's so family. I can't afford it. It's a financial burden on my family. And because of this and Roe combined together, when they start working together, that's how we end up where we are now. Okay? It's kind of fitting together, the puzzle pieces fitting together on how we got here. Okay, next case is Planned Parenthood of Southeast Pennsylvania versus Casey. I mean, generally speaking, it's called Casey. Okay, and this is another interesting one because in the recent decision where they ended Roe as a federal right, this is where this is one of the cases that they included in it. They said Roe and Casey. Okay, so this is important to us. The Pennsylvania legislature amended its abortion control law in 1988 and 1989. Among the among the new provisions, the law required informed consent and 24-hour waiting period prior to the procedure. A minor seeking an abortion required the consent of one parent. The law allowed for a judicial bypass procedure. A married woman seeking an abortion had to indicate that she had notified her husband of her intent to abort the fetus. These provisions were challenged by several abortion clinics and physicians. The Federal Appeals Court upheld the provisions except for the husband's notification requirement. Okay? This is really devastating. Then it says, can a state require a woman who went to an abortion, who want an abortion, to obtain informed consent, wait 24 hours? This is the question that the court had to answer. If married, notify her husband, and if minors, obtain parental consent without violating her right to abortion as guaranteed by Roe v. Wade. And this is a really interesting case. In a bitter 5-4 decision, the court again reaffirmed Roe. Now, when we say reaffirmed Roe, remember what Roe is. Woman has right to abortion. It's the trimester system, right? And the child's not alive. It's just not a person. Doesn't matter. The court again reaffirmed Roe, but it upheld most of the Pennsylvania provisions. Oh, that's interesting. The first time the justices imposed a new standard to determine the validity of the laws restricting abortions. The new standard asks whether a state abortion regulation has the purpose or effect of imposing an undue burden, which is defined as a substantial obstacle in the path of a woman seeking an abortion before the fetus obtains viability. So they're worried about the state slowing the girl down to get her abortion, and then she becomes viable, and then she can't do it. Okay? Under this standard, the only provisions to fail the undue burden test was the husband notification requirement. In a rare step, the opinion of the court was crafted and authored by 3 justices, O'Connor, Kennedy, and Soter. Okay? Now, this is what they call a plurality decision. Plurality, meaning there was 3 decisions, and it was a 2, 3, and then 4. 2 were for leaving Roe as is, don't change it. 3 wanted to change Roe. They wanted to change some of the structure of it. They wanted to change the trimester to a bimester. They wanted to lower the viability age because medical advances had made it more viable earlier. Viable meaning it could survive outside of the womb. I don't get that. I guess when it can survive outside the womb, you're going to take it out. And they changed the analysis, from undue burden standard. It used to be strict scrutiny. Okay? So the most notable findings of Casey were there were 8 Republicans appointees on the court, and only 2 justices had previously shown support for Roe, right? And yet they go after the court and say that it's a political organization. It's based on politics. But here, in this case, there were 8 Republican-appointed justices, only 1 Democrat-appointed justice, and they still ruled in favor of Roe. Is that crazy? It upholds the essential holdings of Roe. A woman has the right to an abortion because she has the right to privacy. This privacy only works because the child is not a whole person under the law. It changes the standard from strict scrutiny to undue burden. It changes the trimester system, which is 28 weeks before the state has an interest, to the bimester system, which is 24 weeks. Removes men from the decision of whether to bear or beget a child. Huge. So you got a guy, the girl gets pregnant. Hey, not my choice. You decide. I'm out of here. And that's been going on for a long time. And I think this one decision has done a lot of stuff to harm, marriages and families, and excluding men from the decision. Bad thing. Bad thing. So this is one of those cases. Remember, I gave you that first Latin phrase, saying one thing excludes another. So saying that a woman has this right, it excludes men. And that's where this really applies. You can see that very plainly. And by doing that, like I'm saying, I think they were destroying families. So the next case, and it's our last case for tonight, is Dobbs versus Jackson's Woman Health Organization. And this is the most recent one. We've probably all heard something about it. So Supreme Court Justice Anthony Scalia, he's not alive anymore. He passed away. He was replaced by Neil Gorsuch. Okay, but he wrote this a few years ago. In Roe v. Wade, the Supreme Court declared unconstitutional state statutes that in no way contradicted any specific provision of the Constitution. No way. The other thing, let me go back 1 second here. The other thing about Casey is that it breaks stare decisis because they changed part of the ruling. So it's not like this stare decisis that we're going to see here in Dobbs is unprecedented. Not with this stuff. They changed the time, they changed the dates, on when it could happen. They changed there's a number, we just went over those things. But all those things are what they call stare decisis. So anyway, the facts of this case is 2018, Mississippi passed a law called the Gestational Age Act, which prohibits all abortions, with few exceptions, after 15 weeks gestational age. Jackson's Women's Health Organization, the only licensed abortion facility in Mississippi, one of its doctors filed a lawsuit in federal district court challenging the law and requesting an emergency temporary restraining order, TRO. After the hearing, the district court granted the TRO while the legislation proceeded to discovery. After discovery, the district court granted the clinic's motion of summary judgment and enjoined Mississippi for enforcing the law, finding that the state had not provided evidence that the fetus would be viable at 15 weeks. Why does it have to be viable? Of course, it's not going to live outside the womb at 15 weeks. The Supreme Court precedent prohibits states from banning abortions prior to viability. The U.S. Court of Appeals and the Fifth Circuit affirmed. Okay? So the question is the Mississippi law banning nearly all abortions after 15 weeks gestational age unconstitutional? And this is what the court says. The Constitution does not confirm a right to abortion. Roe v. Wade, and it gives the number, and Planned Parenthood of Southeast Pennsylvania versus Casey are overruled. Justice Samuel Alito authored the major opinion of the court. I want to tell you, if you guys get a chance to read this opinion, you should. It is a brilliant bit of work, and you can hear I listened to the court arguments for all of these cases, but this particular case, the lawyers on both sides, the justices on both sides are brilliant, But this guy, Samuel Alito, his reasons, his powers of reason and deduction are unbelievable. He's a very, very bright man, and his reasons for doing this are just spot on, for my opinion. You know, it surprised me because the court could have decided to affirm Roe, you know, or they could have decided to say, hey, it's a human being, you can't do this. But instead, they turned it back to the people, okay, and doing what they call stare decisis. In the arguments and in their opinions, both sides worried about stare decisis affecting the legitimacy of the court. It says the Constitution does not mention abortion. The right is nearly deeply rooted in the nation's history, nor an essential component in the ordered liberty. The 5 factors that should be considered in deciding whether a precedent should be overruled support overruling Roe v. Wade and Planned Parenthood versus Casey. They short-circuit the democratic process. The justices decided this for us. We didn't get to vote on it. You know, nine lawyers in black robes made that decision. Both lack grounding in constitutional text, history, and precedents. The test they established were not workable. Changed from strict scrutiny to undue burden. And one of the arguments that he made was, is it an undue burden if a woman has to drive 30 miles? Is it an undue burden if she has to drive 40 miles? Is it an undue burden if she has to drive out of state? Where do you draw that line? Is it an undue burden, you know, for her to pay more than $600 for an abortion? What happens if the doctors get paid more and the staff gets paid more and it costs more for? How do they account for that? When you know, that was kind of the thinking that they were having about this undue burden. See, so the test that they were setting up for it wasn't workable. Just didn't work. They caused distortion of law in other areas. You know, so if you tried to apply these workability things to other areas, it just doesn't work. And ruling them would not up in concrete reliance in interest. In other words, it's not going to destroy the country because they would overrule this. You know, and then they send it back to us, the people. And I'm surprised, you know, at how many politicians are wanting to step up and say, well, we got to protect women's rights. Well, if the country wants to protect women's rights, why can't we? Right? Then when, you know, Joe Biden, in all his wisdom and knowledge, he's going to sign a bill or has signed a bill protecting women's rights. One guy is going to make that decision for 340 million Americans. Are we going to, you know, I can't settle for that. I don't think that's right. That's not what the court said, you know. So let me finish with some of my conclusions that I wrote here. So where are we now? The Supreme Court has returned this question to the people and their elected representatives. Each state will decide if abortions are to be legal. There could be 50 different definitions of when does the state recognize personhood of the interuterine child, or 50 different definitions of when life begins, or even some combination thereof. Or Congress could take this issue from we the people and pass the law legalizing abortion for the nation. That means that 535 voting members of the House and the Senate, 435 representatives, 100 senators, would be deciding this question of significant ethical and regulatory responsibility for 340 million Americans. Whatever action that is taken, it will have to not conflict with the Constitution in history, text, or spirit. For example, to codify Roe v. Wade would mean that they would have to explain how a human being could not be a whole person under the law, and not have that assumption be in conflict with the 13th, 19th Amendments, and not be in dispute with the Due Process Clause or the Equal Protection Clause of the 14th Amendment. Because this would become federal law, it could and should be challenged in the Supreme Court once again. Now, the Supreme Court has said, we're not going to hear this case, but if the federal government decides to take it on, it becomes a federal law, they have to take it. And if they're going to uphold stare decisis, then they have to answer to all the text, history, and the spirit of our laws as to why a human being can't be a person. That's what I think. Okay? I think it is time to end this idea that a human being cannot be a whole person under law. The legislation that I would want to propose would be this, and it's very simple. Every human being is a whole person under the law. Simple. Every human being is a whole person under the law. Second, Congress should have the power to enforce this article by appropriate legislation. That's all we need. It is simple, does not conflict with the Constitution, and is all-inclusive. It's good for everybody. If you can prove that you are a human being, you are a whole person under the law and entitled to the protections of the Constitution. If at some time in the future science discovers that an interuterine child is not found to be a human being, then the legislation would still be appropriate because the legislation would only be for living humans. If you oppose it, you would be saying that slaves should have never gotten free, women should have never gotten the vote. The Indian Removal Act was a great moment in American history. And you would also be admitting that someone else's rights could be greater than your own. Okay, last question. How do we fix this? You know, my amendment is just my wish. It doesn't mean it would happen. But how do we fix this? This is because how do we fix this? Because this is way more than about just abortion. It's about CRT, transgender, and other issues of sex, the 1619 Project, the Lincoln Project, and so on being taught to our children. How does any of that make living in this country any better? Wouldn't it make more sense to teach our children about the Constitution, especially the 14th Amendment, so we'd know who's equal? We're all equal. That's what all the equality they are looking for is based on, is our Constitution. Believe me, it is also about corruption in our government at the highest levels. It's about our real constitutional rights being eroded. It's about dark money, foreign influence, and billionaires putting their thumb on the balance scales of our elections. It's about one political party doing whatever they can to entomb the other by calling each other names like extreme whatever, extreme MAGA, extreme left, extreme right, whatever. So we still haven't decided how to get there. How about praying before we vote and not voting for a party, a Democrat, Republican, Independent, whoever, not a single issue like your union or abortion or guns or the economy, but rather for the most virtuous candidate. For the more virtuous we are, the more freedom we have. Thank you. So I guess while I'm here, if you had questions, I'll do the best I can to answer them. I know Mel says he's going to torment me, so. Yeah, okay. Okay, well, there's no questions then, I guess.
Craig, what was the political situation at the time where where the people making these decisions could decide that someone didn't have a full vote?
Are you talking about in the Constitution? Yes. Okay. So what happens here is that we have our 13 colonies, okay? And they decided that they're going to become a country. Half of the country has slaves. Many of the founding fathers had slaves, okay? And the way they treated the slaves were different from one side to the other, you know? So what happened is, if they decided that they weren't going to have any slaves, because there was a lot of talk about this in the Continental Congress, there was before they adopted the Constitution, in the writing of the Declaration of Independence, this was discussed, and they decided that they would have to allow slavery to keep the states together because there was so much money spent to get slaves. The other thing is that because they were considered to be property, the North liked them having property because it meant taxes. So it was kind of in favor for both of them. That's interesting. And so that birth defect was put into our Constitution, you know. In the same breath, you know, Indians not taxed, you know, and what we were talking about here is the slaves were 3/5 of a man. Okay, and I think the reason that they did that was because it would take longer for them to become not slaves if they were to be, like if it was half, you could be out of it in 3 generations. But 3/5 required like 5 generations to clear it. It's an odd number, you know. So I don't quite understand all of that, but for sure, it was because the North wanted the taxes, the South wanted the slaves, the South wanted to have the votes because this is about counting seats for the House of Representatives. And so they would say slaves were worth 3/5 of a man, so every 5 slaves were 3. That's how they counted it. Yeah, interesting. Any others, or?
What year was the Native Americans thought as a person? Was that the latest one?
Say it again, no?
You remember how women's suffrage, you said some year?
Oh, there was an act of Congress, and it's about the same time that women get the vote.
No, not that. I'm talking about the indigenous Indians, I guess.
Oh, when were they? They were in the same breath in the Constitution. You know, I can read it to you if you'd like me to.
What year was that?
In the founding of the country. That's how far back this goes. Yeah. It's in the section 2 on the first page at the bottom. It's in there, you know. Including Indians not taxed 3/5 of all other persons. So if you didn't want to count Indians, you just didn't tax them. And this is a tough thing that happened to them because they were born of the Indian nation. And our immigration laws were only for people who immigrated here, but they were here already, so they couldn't be citizens because they were born of the Indian nation. And it took forever, and it was like 1921, if I'm remembering correctly. Yes, sir.
Wasn't the Constitution, when it was written, inspired a lot by the Magna Carta?
Yes. Yes, I believe so. Yeah, there's a lot of that in there. You know, they relied on a lot of the old wisdom of that came from Europe, and a lot of the things that happened in Europe, like we were talking the other night about the Second Amendment. And the Second Amendment, I'll read it to you so I don't mess it up, because I can generally recite it, but I want to make sure I get it right. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay? So where did the idea of militia come from? Came from Europe. If you were a European male, and you were of age, and you were working in the field, and an army marched up on your village or on your town, call to arms. And oftentimes, the religious leaders, Catholic Church or the Anglican Church, the Church of England, would show up. The priest would be in front, and he would say, "You don't want to fight God, do you? Lay down your arms." So they would put down their arms, and the armies would march in, and then they would go to work on them and start saying, "Well, you were going to defy us, and that's blaspheme because we're God's people," and and they would take them out and torture them and murder them. And so the founding fathers knew that was part of the history of mankind, and they didn't want that happening here. So if an army of anybody marches up here, we don't have to lay down our arms. That's what that's about, you know. Yeah, it's an interesting bit of history that I didn't know about until a few weeks ago when I was doing some more studying. I came across it. The other thing is, it's interesting about this, remember we was talking about it's not just what it says, it's what it doesn't say. You know, it doesn't say that every person has to join the militia, but you can't join the militia without being armed, right? So if you have arms, you don't have to join. Maybe it's an issue you don't want to get in a fight with. Be like California fighting the federal government because they want to have whatever. And so they call the arms, all the militia, and I don't want to fight the federal government, so I don't agree with most of what they do. And so there you go. I wouldn't go. Even though if I have an arm, I wouldn't want to join them. But I couldn't join them unless I was armed. See how that works? It's not just about what it says, it's also about what it doesn't say. Any other questions? Great, I appreciate it, guys. Pastor, I'll turn it back over to you. Thank you, guys.
Pray together. Father, thank you for the fascinating insights that most of us were not even aware of. As Clyde just walked us through like about 50 years of history on this whole abortion issue. Now we're armed. Now we have the opportunity to purchase a book and understand a concept that is extremely relevant and highly emotional in the minds of so many people. And it doesn't have to be an emotional thing. It's based on our facts, our understanding of the Constitution, and our God-given rights. So thank you so much for the time that he has spent in researching this and for the wisdom and insight that you've given him. He's not a lawyer, but he has an excellent mind, and we thank you for him in Christ.